All right. Everyone, we are welcoming an amazing guest today, a former board chair for the Nebraska Council on Economic Education, and someone who just happens to be very well versed in estate law and estate planning and stuff like that. And this was certainly one of the topics that was brought up by teachers last year in our surveys, that this was a topic that they wanted more information on. I'm not sure if they wanted the information for themselves or for their students, but it doesn't matter either way. We're going to hopefully be able to help you out here today. And I want to welcome Brett Ebert to our wonderful webinar here, and I'll let her take it from here.
Great. Thank you, Matt. Thank you for inviting me to do this today. So as Matt said, I was previously the chair of the NCEE board, still a board member, and have been since I think 2014 is what Jennifer and I were kind of looking back on. So this has been a really rewarding board to be a part of. So it was an easy yes when Matt asked me to jump on and do this presentation. So a little bit about me and my day job. I am an estate planning and business law attorney with Ball, Loudon, Ebert, and Brostrom. So we are a boutique estate and business planning firm. We have offices in Lincoln, Omaha, and then also Grand Island. So we really try to have almost a statewide presence. All we do is estate and business planning. We don't do litigation. We don't do criminal law. I've had the luxury of being able to specialize in estate planning as an attorney pretty much from day one. So the point of today's presentation is really just to give you an overview of the estate planning process, why it's important. We'll cover some tax concerns, and then I'll make sure to leave plenty of time for questions. So I love questions in these types of talks, so definitely feel free to get those ready. So we always like to start by saying, if you don't have an estate plan, meaning you've never done a will or a trust, the reality is you actually do have an estate plan. It's just that the state of Nebraska writes one for you. So that is called intestate. If somebody dies without a will in place, we say that they have died intestate. That's the rules of intestate succession are what the state writes for you. Here's just some kind of common examples that we see. So for example, if you die and you don't have a will and you're survived by a spouse and children, and all of those children are of your marriage with your spouse isn't automatically entitled to everything. Instead, they get the first 100,000 of what you own plus half, and then your children get the other half. This can cause a lot of problems, as you might imagine, because we could have minors inheriting assets that really would have preferred we go to the surviving spouse. And then if we have minors inheriting, we have to set up guardianships and conservatorships with the court. So it can really leave things quite complicated. Another one that often that kind of surprises people is if you die and you have a surviving spouse but no children, your spouse again doesn't automatically get everything. Instead, they get that first 100,000 plus half, and the rest actually goes to your parents. So again, these rules that the state writes for you often are not what most people would actually want to happen. So what are the kind of key components of an estate plan? Definitely a last will and testament, and possibly a living trust. We'll talk about what that is and the benefits of that. A durable power of attorney that deals with finances, a healthcare power of attorney and advance directive, and then I include beneficiary designations as a key component of your estate plan, and we'll talk about why that is. So first, it kind of helps to talk about some terminology. So we talk a lot about probate property or non-probate property. So probate is just the process where we have to go to court and administer someone's estate through this probate court supervised process. Probate property is any property that would be subject to that administration. A common example of probate property when you have maybe like a single person who owns real estate, almost always that home is probate property if they would die, because it is just in their name. If you die with any assets in your name alone that have no beneficiary designations, those are probate assets. Non-probate property would pass according to beneficiary designations or how things are titled, or if you have those assets in a trust. One really common misconception that I like to kind of clear out before we get started is that non-probate property, so if you put your children on as a beneficiary on your bank accounts, or you put your children on as a co-owner of your home, people think that that is going to avoid Nebraska inheritance tax or the federal estate tax. That is not the case. So regardless of whether you die with probate property and non-probate property, most of it, all of it, is still subject to the Nebraska inheritance tax. So a trust, at least the type we're talking about today, would not do anything to avoid Nebraska inheritance tax. So the probate process, when somebody dies, takes about 9 months to a year for a simple probate. So there definitely is a time delay with that process. We work with the personal representative or executor, that is the person who's in charge, to figure out what the decedent owned, gather up all of those assets, get them liquidated. We determine any debts, expenses, taxes, get all of those paid, and then at the end of the process, distribute assets to those beneficiaries. So we kind of talked about what probate is. Now let's talk about how we get to a probate, or how we maybe try and avoid probate if that is one of your goals. So most people have heard of a last will and testament. This is a pretty common estate planning tool. What does it do? At its core, it tells what happens to your stuff when you die. So within a will, we can provide for distributions to your children, to your spouse, to anybody that you want. We also typically include language allowing you to create what's called a laundry list. So a laundry list is a separate document that you can do outside of your estate plan that will say, you know, I want my wedding ring to go to this person. I want these tools to go to this person. Those laundry lists can be really valuable when somebody passes away, because I'm sure almost all of you have heard horror stories of children or family members fighting over stuff when mom and dad die, and that's unfortunately quite common. It's really easy to divide up a bank account or an investment account. It's really hard to divide up mom's wedding ring or pieces of art, things like that. So if your estate plan, which any estate plan you do with an attorney should give you the ability to do this laundry list, I really encourage people to take advantage of that. Your will is also where we would name your personal representative. That's what we call it in Nebraska. Executor is another common word that people use for it. This is just the person who's in charge of the probate. So this is who is going to be actually interacting with the attorney in the court to figure out where all of your stuff is. This is who has authority over those probate assets. So if you die and we have a probate and your house is just in your name, once we get someone appointed your personal representative by a judge, then they have authority to sell the house, change the locks, get insurance, do all of that stuff. A will is also really important if you have minor children, because this is where we're going to name guardians of those children. So this is who, you know, if you have anyone who in Nebraska, age of majority is 19. If you have children under the age of 19, really important to name guardians of those minor children should something happen to both of their parents. So most of our clients come in and already have heard enough about probate to think that it's a four-letter word and know that they want to avoid it. I always preface by saying probate in Nebraska is not really the end of the world. There are states where you absolutely would want to avoid a probate, and that's because of the cost and expense system associated with those states and the way that they charge fees for probate. So for example, I know in California, The court fees associated with a probate depend on the value of the assets. That's not the case in Nebraska, assuming we're doing an informal probate. So it's not the end of the world to have to do a probate in Nebraska. But that being said, I would say the vast majority of our clients are interested in avoiding probate. And that's where we talk about doing a trust. So a trust at its core is a contract. It's a contract between the person who's creating the trust, who we call the grantor, and the person who's in charge of it, who's called the trustee. So the trust itself is just the contract that is the grantor telling the trustee how to administer the trust, what to do with the assets that are in that trust. There's two kind of main types of trusts that we deal with, and that would be a testamentary trust. That is simply a trust that is tucked into a will. So if you have minor children and all you have is a will, chances are you have within that will what's called a testamentary trust. So that would say, if something happens to both me and my spouse, everything goes to my children unless they're under the age of 25, then hold it in trust until they turn 25. So that would be a testamentary trust. The way that we avoid probate is by using this living trust. That's just a trust that you create during your lifetime and you actually fund or put assets into during your lifetime. So with the living trust, the main benefit there is that probate avoidance, which allows us to avoid a lot of attorney's fees when you die, as well as court costs. Another benefit of a living trust during your lifetime really has to do with asset management. So if you were to become incapacitated and we had a trust, it's a lot easier for the person who's named as your successor trustee to go in and manage your assets for you under that trust, as opposed to just relying on a financial power of attorney. That financial power of attorney is still important. We have just noticed that a lot of financial institutions have become leery of working with powers of attorney because they do sometimes get abused. And it's just a little smoother path for someone to manage mom or dad's assets as a trustee instead of just relying on that power of attorney. Trust can be either revocable or irrevocable. Revocable just means we can change it. Irrevocable means it can't be changed. So a trust that you create during your lifetime as an estate planning vehicle, that would be a revocable trust. At your death, that is when it becomes irrevocable, meaning we can no longer change it. There are certain times we may create an irrevocable trust during your lifetime. That is a very specific type of estate plan that you'd have to talk to your attorney about. But what we're talking about today primarily are those revocable trusts. In your trust, you're going to name a trustee. So that is who is in charge, that's who has authority over that trust. So typically when you create a revocable living trust, you're going to be the trustee as long as you're alive and have capacity. But then at your death or incapacity, we need someone else to step in and start managing those assets for you. We always want to make sure that people understand that trusts sometimes historically have almost been sold to people in a almost predatory manner, I would say, where I have clients sometimes come in with giant binders and I can tell right away where they got their trust from and that it's probably not super tailored to them. So we always just recommend that trusts are, you work with an attorney that you know or that you've had a good referral for, and that it really is tailored to your specific situation. Okay, we already kind of covered that, but that revocable living trust, again, is something that we could change during your lifetime. So the main thing we do in this trust is say where your stuff goes. So instead of your will saying, give everything to my kids, your trust would actually say that. And then your will serves a very limited purpose to just transfer anything that might be in your name alone into your trust. So if you have a trust-based estate plan, you are still going to have a will. It's just that your will is what we call a pour over will. It just says everything I own in my name, put it into the trust. The will is just there as a backup. The goal is that we never need your will because everything's already owned by your trust when you die. Just like in the will, within that trust, we can provide for that laundry list so that you can say where you want specific types of personal property to go. And then again, we're going to name that trustee. I think picking your trustee is one of the most important decisions that a person can make in your estate plan. For the vast majority of our clients, where the stuff goes, who's going to get it, that's typically pretty straightforward, right? It's usually we want everything to go to our spouse if we have one, and then children. If we don't have children, then we're talking usually nieces and nephews, friends, charities. That's usually not the hard part. That's usually pretty straightforward. Who's going to be in charge? That is often a bigger question, and one that I always really try and counsel clients to think about who the best person for that job would be, because that's what it is. It's a job. It's not an honor that you're bestowing on someone, it's a burden. So the trustee's job would be to potentially manage your assets for you while you're alive. And then at your death, if you have children who are still young or any beneficiaries who aren't going to just get their money right away because maybe they have a special need or have a reason why we wouldn't want to just turn over a pot of money to them at your death, that trustee is who they're going to go to whenever they want money from the trust. So the trustee can be a person. I always want people to name someone who's obviously very trustworthy. We don't want someone who's a procrastinator. We want someone who's pretty organized and pretty sophisticated when it comes to dealing with finances, interacting with financial professionals, that kind of thing. Another great option as a trustee is to consider a corporate fiduciary. So this would be a bank or a trust company. There are people whose literal day jobs are to serve as trustees for folks. I'm a big fan, our firm is a big fan of corporate fiduciaries because it just removes all the family dynamics from a trust or an estate administration, and it just takes that burden off of the people that you leave behind. So creating your will or your trust is really just step one in your estate plan. A very important step two is looking at how you own your assets and what your beneficiary designations are. So a very common type of asset ownership is joint tenants with rights of survivorship. This is how the vast majority of people own real estate with their spouse. So if you went and found the deed from when you bought your house, it probably says, your name, your spouse's name, husband and wife as joint tenants with rights of survivorship. That means if one of you dies, the survivor owns the entire house. Another type of ownership is called tenants in common. Tenants in common means that you each own an undivided interest in that real estate. We see this type of ownership commonly if siblings inherit like ag land from parents. Often those siblings will own that land as tenants in common. So if you own land with your brother and it's the two of you, it's not like we can draw a line down the middle of that farm and say, this is his half, this is her half. Instead, what that means is that both of you own an undivided one half in the whole thing. But if one of you dies, your interest goes according to your own estate plan. It doesn't just automatically go to the other person. We take advantage of the ability to do payable on death or transfer on death designations and beneficiary designations all the time. So you can add these to bank accounts, investment accounts, retirement accounts. And I talk to clients about every type of asset that they have and making sure that their beneficiary designations line up with their estate plan. For example, if your trust says split everything equally between my 3 children, but your retirement account says 100% to one child because maybe you set up that beneficiary designation before you had three children. Doesn't matter that your trust says split it three ways. If that beneficiary designation says give it to one person, that's where it's going to go. So this is a huge piece of your estate plan. We generally recommend against putting adult children on as co-owners of real estate or bank accounts. And that's for liability reasons. If you put your children on as co-owners, you're subjecting your property to their liability. So if they're married and then they get divorced, that asset could become part of it. If they have any creditor issues, that asset could become part of it. So there's better ways to get your stuff to your kids than putting them on as co-owners. I am going to answer some questions that Jennifer put in the chat here about trust. So is there a ballpark asset threshold when you would or would not consider a trust? It's, for me, less about the value of your assets and more about the nature of your assets. So if you have real estate, that kind of lends me towards, okay, maybe we should talk about a trust, only because our only way to make real estate a non-probate asset when you die is to use what's called a transfer on death deed. That can be a useful tool in very limited specific circumstances. So a transfer on death deed allows you to essentially do a beneficiary designation for real estate. The problem with transfer on death deeds is if you have 4 kids and we do a transfer on death deed to 4 people, the minute you die, I have 4 co-owners of a house. I don't really want to deal with 4 people when I'm trying to get a house sold. I'd rather have a trustee or a personal representative, one person who's in charge of that, making decisions. There's also some issues with liability insurance, property insurance, and transfer on death deeds. So that's why I really don't like those. If you have children with special needs, or we know for sure that after your death, a trust will continue beyond your lifetime. So if you have somebody who, for whatever reason, we just know there's no point in time in this person's life when we're going to hand them a bucket of money to do whatever they want with, we're going to keep it in trust for them for forever. I would rather do that under a living trust type of plan than a testamentary trust. And that's just for administration reasons. If you have real estate in more than one state, I really want you to have a trust, because then I'm worried about a probate not only in Nebraska, but also other states where you own real estate. Another question would be, what is the cost of a corporate fiduciary? And asset level for a corporate fiduciary, great question. So most corporate fiduciaries, if they're just doing a 9-month to a year administration process, a lot of them will actually just charge hourly for that. Typically no more than 1%. So the most you'd be looking at is like a 1% fee. On an ongoing basis, most of them charge 1%. And then it goes down after like 1% on the first million, and then the percentage goes down beyond that. So that's a pretty common cost. I tell people, if you have a corporate trustee, I can almost guarantee you that my fees when you die are less if I have a corporate person in charge than an individual, because I don't have to spend 10 hours time getting someone up to speed on what we're even doing here. So your attorney's fees when you die are probably going to be less if you have a corporate trustee involved. If there's any hint of conflict or drama between the people who are going to be inheriting from you, really encourage folks to use a corporate trustee in that situation. Whatever child ends up serving as mom or dad's trustee or financial power of attorney typically gets a target on their back. There's just an automatic level of um, mistrust or suspicion. I don't know if it's jealousy, sibling stuff. I'm an only child, so I can't fully relate to that piece of it. But from what I've seen in 12 years of practice, is it's just hard for the child that ends up getting stuck with that job. And then asset level, that is a good question. So most corporate trustees we work with locally, as long as we know that there's about 250,000 plus involved, they're willing to serve. So I would say that'd be like the minimum threshold for a corporate. Okay, so question about taxes and costs that go with death. We don't want to leave those expenses as a burden. People worry about this a lot. So yes, when someone dies, there's costs associated with that. There's often a funeral to pay for. There may be some Nebraska inheritance taxes, and we'll talk about those. There's often final medical bills or, things associated with that. Sometimes we have to get a house cleaned out, that kind of stuff. We only look to the assets of the person that has died. So we actually have a process when somebody dies where we give creditors a certain period of time to file a claim. If they don't file a claim within that period of time, they're barred forever. So we do have this, it's in the probate process, but we have the option to basically tell creditors, okay, you have 3 months to file a claim. If you don't file, you're cut off. If more claims get filed than we have assets, then we start talking to creditors and we have an insolvent estate. Nobody's going to get paid their full amount. And we just kind of work through in priority order. The beneficiaries should never be dipping into their own pocket to pay those final expenses. And as far as inheritance taxes go, if there's no assets, there aren't going to be taxes. So the taxes will get paid from the assets of the estate. One thing people also worry about is I see a lot of clients who put one of their children on a bank account as a co-owner, and their reasoning for it is, I want to make sure when I die, my son has money right away to pay for the funeral or to pay expenses. Really appreciate that sentiment. The reality is everybody can wait. Nobody actually needs to get paid within 24 hours of your death. So I would rather we make sure your assets are titled to fit in with your estate plan. And just knowing that it might take a week to get somebody paid, that's okay. Most people who are in this business understand that if somebody dies, they're not going to get paid right away. Funeral homes are pushy. I know that. So that sometimes we do have people having to pay and then get reimbursed from the estate, which we absolutely can do. So, okay. So durable power of attorney. This is a really important document for everyone who is over the age of 19 to have during their lifetime. So what this does is it allows the person you name to do anything with your finances that you can do. So if you are unable to file your tax return, this person can do it for you. They can make investment decisions for you. They can take money out of your bank account. Almost every power of attorney that we draft is effective immediately. So you don't actually have to be incapacitated before the person you name can act on your behalf. The reason for that is proving your incapacity is sometimes difficult, and sometimes people have periods of incapacity. So we tend to not like to make these contingent on you being incapacitated. So because of that, you should only name someone that you trust implicitly in this role. There's a couple of things that the person named in your power of attorney cannot do unless the document specifically says so. One really big one is give away your money. So if your power of attorney does not include gifting powers, the person you name, if you're incapacitated, can't write checks to your kids or your grandkids at Christmas on your behalf. So talk to your attorney about whether or not you want that power included. Healthcare directive also includes a power of attorney for medical. So we combine those into one. This is who can make medical decisions for you if you're incapacitated. It also includes that living will language that deals with, what kind of care or treatment you would want for end of life decision making. And then a big thing in there is a HIPAA release. So we want to make sure that the person that's named is actually going to be able to get information about your health. So we will jump into taxes. I'm going to spend just a little bit of time at the federal level, but then spend more time at the Nebraska level because that's the one that applies more commonly. So one thing I always like to talk about with gift taxes is that most people have some kind of concept of there's a certain amount I can give every year and not have to pay tax on. That's what we call the present interest annual exclusion. And for 2025, that number is $19,000. So I could give each one of you $19,000 this year and not have to worry about any kind of gift tax. If you gift more than that, you're not likely going to owe a tax. Instead, all you do is start borrowing from your lifetime exemption from the federal estate tax, which is currently $13,990,000. So the vast majority of us, fortunately or unfortunately, don't have to worry about the federal estate tax or the federal gift tax. So if people want to make gifts bigger than 19,000, typically not a problem. We just have to report that gift to the IRS through a gift tax return that your accountant can help you with. So I already kind of touched on this, we'll sort of skip. The current exemption from the federal estate tax is at $13,990,000 per person. So for a couple, we can double that because we have this tool called portability. Within 9 months of someone's date of death, we can file a federal estate tax return and transfer that person's unused exemption to their surviving spouse. So we are doing a lot of federal estate tax returns only for the purpose of preserving portability. You don't just get it automatically, you have to file a return and make that election. So if you have a parent that's died or family members that have died, and we don't have a federal estate tax problem right now, but because the assets are appreciating or somebody is young, we're worried that we might in the future, we often will go ahead and file that portability return to make sure that we preserve that big exemption. Currently, if Congress does nothing for this next year with regards to federal estate taxes, that number is going to go down from the $13 million to $5 million a person adjusted for inflation. So we think that'll probably be around 7 million. Okay, so the Nebraska inheritance tax. So I want to make sure I leave us plenty of time for questions. This one affects almost every estate that we work on. So about half of what I do is on the deceased side of things, working with families after people have died, helping them navigate the probate process, as well as the Nebraska inheritance tax process. Our rules changed a little bit in 2023. Our inheritance tax in Nebraska is very unique because we look at the relationship between the person that's died and the person that's inheriting the money to determine the level of tax. So anything going to a spouse, no tax. Anything going to charity, no tax. But everybody else falls into one of 3 categories. So we have class 1 beneficiaries or close relatives. These are children, grandchildren, and siblings, and anyone married to those people. Each of those individuals get the first $100,000 inheritance tax free, and then they pay a 1% tax on everything above that. So if you have 3 kids and they're each going to inherit $300,000, then they each get the first 100 inheritance tax free, and then they would pay a 1% tax on the 200. Class 2 beneficiaries are what we call remote relatives. So that would be nieces and nephews, cousins, kind of that level of relationship. They only get the first $40,000 inheritance tax-free, and then they pay an 11% tax. Class 3 beneficiaries are non-relatives. So this is anyone who's not related to you. This would include a partner who you're not married to would fall into this class 3 beneficiary category. They get the first 25,000 inheritance tax free, and then we pay a 15% tax rate. So this tax, if we're going to anyone other than close relatives, can add up fairly quickly. This is due 1 year from someone's date of death, and it's paid at the county level. So if you live in Lancaster County, the check goes to the Lancaster County Treasurer's Office. If you have real estate in more than one county, we kind of divide it up between the counties where you have real estate. If you have someone who's under the age of 22 inheriting from you, they don't pay any tax. That's new. So that federal state tax, if there is one, that's due 9 months from date of death. Nebraska inheritance taxes are due 12 months from date of death. One more thing about the inheritance tax. When you die owning real estate in Nebraska, an inheritance tax lien automatically attaches to real estate. So if you've, let's say, done a transfer on death deed to your child, great, you've avoided probate. We didn't really have to do anything when you died. It was easy. But your child, say they inherit the house, they decide to live there or keep it as a rental, and then 5 years after your death, decide to sell it. But they never went and saw an attorney when you died because it was so easy. Well, then when they go to sell it, we realize there's a lien attached to that real estate, and that tax has been accruing interest and penalties after that 1 year. So this is just something to make sure that children or that you're aware of, that this affects almost everyone that dies in Nebraska. So something needs to be done within that 12-month period of time. The only asset that is not subject to the Nebraska inheritance tax is life insurance that's payable to a named beneficiary. So if you have your spouse or your children or a trust listed as the beneficiary on life insurance, it's not subject to the tax. But if you wrote estate as the beneficiary on your life insurance form, that's going to be subject to the Nebraska inheritance tax. Any real estate you own outside of the state is also not subject to tax. So if you own a cabin in Colorado, that would not be subject to the Nebraska inheritance tax. So we would love to make estate planning a more simple process, but we don't know when you're going to die or lose capacity. We don't know what you're going to own. We don't know the value of what you're going to own. We don't know what the tax and other applicable laws will be. We don't know if people will survive you. We don't know your order of death. And most clients are unwilling to commit to dying first to make things easier for us. So that's why this feels complicated. Estate planning really is not a do-it-yourself process. We like to recommend people really do seek competent professional help with estate planning. It is a lot more expensive to try and fix something that's wrong than to have had it done right the first time. We really advocate a team approach to your estate plan. So if you have a CPA, if you have a financial advisor, if you have an insurance agent that you work with, we want all of those people involved in the process so that all of these parts and all of these beneficiary designations all come together to really make sure that your plan works. So with that, I'm happy to take some questions.
All right. Please feel free to either put them in the chat or you can unmute yourself and ask them. I'm sure we all have amazing amounts of questions. I can get started. What I know, like obviously is something we worry about much later in life, but when is the best time to start? When is the most realistic time to start planning these type of things?
Yeah, that's a great question. I typically we see people do an estate plan like at most maybe 3 times and throughout their life. So the first time when most people do an estate plan is when they have young children. So that's really common working with young families. Um, then people sometimes change things when their children become adults, because when they're little, we're not naming them in these important roles. So when they become adults, we want to update that. And then sometimes as people get older and they know their kids are really settled and stable, then maybe they change things to include grandchildren. So really there's like 3 milestones, I would say, but truly, if you are over the age of 19 and you have stuff, even a little bit of stuff, technically you should have an estate plan. So those powers of attorney for young adults are pretty critical. We often do those for clients who have, maybe children in college, because God forbid there'd be an accident, a child would become incapacitated. If they're over the age of 19, even as your parent, you don't have the ability to necessarily make medical decisions for them. Now, we do have laws that have made that easier, but we still typically recommend that. So Jennifer asked, can you share what we should expect to the cost, basically? So it can vary pretty wildly, honestly, across the state. Obviously, as we get, closer to Lincoln and Omaha, I think it tends to get more expensive. We typically do estate planning on a flat fee basis. So for a will-based estate plan for a young couple, that's typically around $1,000. For a trust-based estate plan, it's around $2,000. If we're doing two separate trusts, it's around $3,000. So if you're working with an attorney, probably budget anywhere from 1 to 3,000 for an estate plan with an attorney. Someone asked, is there a specific time frame that a trust has to be enforced before it takes effect? I've heard 7 years. So a revocable living trust that you create, like what we're talking about here, that's effective as soon as you sign it. There isn't any period of time. I wonder if this maybe has to do with Medicaid planning. So if you're trying to transfer assets out of your name so that if you need long-term care, you don't have to spend those assets down and pay for your care before you qualify for Medicaid, the rule is 5 years. But that just has to do with, like, if you gave a farm to a child, 5 years needs to go by before we would still count that as a resource for you. I've recently seen some real estate that is titled John Doe. Sorry, part of this is hidden. Does it say on death? There's like a little
Because I have
bubble in front of
recently
this.
oh, I have recently seen some real estate that is titled John Doe, transferable to Billy Doe, Sally Doe, and Susie Doe on death. Can you visit about that?
I This is probably referring to maybe what's called a life estate deed. So you can transfer, like if I had a farm, I could transfer it to somebody now, but reserve a life estate in myself so that while I'm still alive, I am entitled to all the income off that farm. I'm responsible for all the expenses. But then when I die, it's already owned by the remainder beneficiaries. That can be a helpful technique in certain circumstances. So there's some downsides with that, but that's probably a life estate deed. This can be a really helpful tool for farms, for people who are worried about needing to sell a farm to pay for long-term care. A life estate deed can help with that. The biggest downside with a life estate deed is that it's really hard to put the toothpaste back in the tube if you end up deciding you don't like it, because what you've done is effectively given that real estate away. You've just kept the life estate for yourself. So you couldn't decide to sell it and keep all the money from it. That would not work. So we have, what if a will just needs to be updated? Is it okay to use a different law firm? It is absolutely fine to use a different law firm. Sometimes we're able to just do amendments to wills. Those are called codicils. So if there's just one piece of it that needs changed, we can do that simply. I'll say like for me, if we're doing a lot of changes, it's often easier to just start over. So if you switch law firms, I think your biggest risk is that you may start over at a full new, like flat fee or fee to update that.
Okay, I'm going to ask this question out loud because you may want some clarification. So if I have a will that my husband and I created. Um, what if we would both pass away? Like, are those stored in a database? Like, I don't know if my kids would know where it was. I mean, I think they would, but are those like, how do we know if somebody has a will? Do you understand what I'm asking?
I do. Yeah, that's a really great question. And the answer is no, there is no database. Wills are not filed anywhere because they can always be changed. And so we don't have like a repository for wills or estate plan documents. So what I always recommend that clients do is make sure you leave breadcrumbs. So your kids or whoever is, gonna inherit from you, they don't need to necessarily know what's in your will. They don't need to see it before you die, but at the very least, I would recommend you tell them, we've done an estate plan. Here's the name of the attorney who did it for us. If something happens to us, call this person. I'll never forget kind of early on in my career, a woman who was kind of frantically going from law firm to law firm in town, trying to figure out where her dad had done a will. She knew he had one. She had no idea who had done it for him. And that unfortunately happens and can be really frustrating. So really it is important to make sure that people know at least a starting point of where to go. I always tell clients, as long as your kids know to call me, I can get them whatever they need to get started. It's just we got to make sure they know where to start.
Thank you.
Yeah.
I have another question too that it might be easier in a chat. If we have a farm that's set up in an LLC that's sort of independent of us, it's owned with my brother-in-law. How does that work with a trust? I'm assuming you would need to see all of that, right? The whole LLC stuff and how that's set up.
Ideally, yes. So typically what we do for any kind of LLC or closely held business interest, if people also do a trust, is just make sure that when you die, those interests automatically go into the trust. So we can do what's called a transfer on death designation for your LLC interest. That's just so we make sure we avoid a probate with that asset. But then kind of related to your estate plan, whenever I have people in an LLC or a closely held business, I always like to look at what does that document say about what happens to those shares when you die? Is there an automatic buyout? Are your kids allowed to become members or owners of that LLC? Maybe now, while that generation is, while the sibling generation is still alive, let's sit down and put in buy, sell language or transfer restrictions, because as we all seen, every generation, it just gets harder and harder to keep something like that together when you've got cousins now in business together. So this would be the time to just make sure that that ownership structure and the transfer restrictions are what you all would want them to be.
Okay. Thank you. I've
Yeah.
actually got an appointment with Andrew Loudon in a couple of months. So,
Good.
so I'm asking what he's going to need in advance. So that's
Yep.
good.
All of your operating agreement would be a good one.
Okay.
So,
Thanks.
yeah.
All right. Do we have any more questions? In the chat, looks like we've answered all of them. In person, does anybody have any last ones? Awesome. Well,
I'm just
thank
gonna
you.
I'll throw my email
Yep.
address in the chat so that if anyone wants to reach out with any other questions,